Here's a quick video on the difference between joint tenants and tenants in common. Hi guys, when two or more people buy property together, you'll be asked how you want to hold that property by your lawyer. And so there's two options. You either hold as joint tenants or as tenants in common. These are funny phrases, joint tenants, tenants in common, but those are the two options. So what's the difference? The key difference is what happens if one of the owners dies. If you hold as joint tenants, all of the co-owners own the property together and they have an equal share in the property. And if one co-owner dies, the others automatically become the owner of that property, regardless of what it says in your will. The property will simply pass to the surviving joint tenant or the surviving joint tenants. In Queensland, not even a person who contests a will via family provision application, trying to get a greater share of the estate, can challenge this automatic transfer of property to the surviving joint tenant. So, as you might imagine, most married couples hold as joint tenants because they're quite happy for their share to pass automatically to the other person. On the other hand, we have tenants in common. This is where each co-owner has a distinct share in the property. They can have different shares. They need not be equal like with joint tenants. They might be 50-50 or they might be 60-40 or 30-70, whatever the co-owners choose. And of course, if there's more than two, that's fine. We can have 10, 30 and 60, for example. And so, where the co-owners own as tenants in common, their distinct share can be left via their will. So with tenants in common, this is a common way for business partners or siblings or friends to hold property so that they can give their own share onward to their own chosen beneficiaries, for example, their family. Can the type of tenancy be changed? The short answer is yes, it can be, but it certainly pays to get it right the first time. A change from joint tenants to tenants in common is very common right after a couple may have split up because they no longer want their share automatically going to the other person, and so they want to change that joint tenancy to a tenancy in common so they can leave their own share onward via their will. This change from joint tenancy to tenancy in common can be done either by both parties or all parties if they agree, or by just one of the parties. So you don't need everyone to agree to go from joint tenancy to tenancy in common. Often it's called severing the joint tenancy. It's a bit of a funny way of describing it, but that's the legal language, severance or severing the joint tenancy. You can also go the other way from a tenancy in common to joint tenants. However, to do this, all co-owners would need to agree and the joint tenants would all need to have an equal share. So if it's not already equal, that could be a problem and would need to prompt transfers of property, which could have duty and tax consequences. So, in short, to wrap up, the key difference between joint tenants and tenants in common is what happens if one of the co-owners dies. In one case, joint tenants, it automatically goes to the other co-owner or co-owners, whereas with tenancy in common, you get a choice. It forms part of your estate and you can leave it via your will. I hope that was helpful. Cheers. Fox out.